Prior to the enactment of the Affordable Care Act, or ObamaCare, many employers provided health benefits to their employees by reimbursing them for the cost of their health insurance premiums or by paying health insurers directly for the cost of employee coverage. The amounts paid by employers under such arrangements, known as employer payment plans, has been a non-taxable fringe benefit under Section 106 of the tax code for over 50 years. While this is still technically true, the Affordable Care Act has essentially rendered these plans obsolete by imposing a staggering penalty on them of $100 per day per employee for employers that continue to use them. Many church leaders continue to offer these plans, unaware of the enormous penalties they face in doing so. There are a few exceptions to these rules that apply in limited cases, including group health plans that have fewer than 2 employees, or that only offer accepted benefits such as disability, dental, vision, long-term care, and certain health flexible spending arrangements. Another option that may allow some churches to continue to pay employee insurance premiums on a pre-tax basis is to participate in the Small Business Health Options Program, or SHOP Marketplace. The SHOP Marketplace makes it possible for small employers to provide qualified health plans to their employees. Some conditions apply. The SHOP Marketplace is open to employers with 50 or fewer full-time equivalent employees. Some churches are attempting to maintain their long-standing employer payment plan and avoid the $100 per day penalty by treating their payments or reimbursements of employee health insurance as a taxable benefit. Many tax professionals have endorsed this workaround, but this potential option was nixed by the Department of Labor in November of 2014 and should not be used. In February 2015, our prayers for relief were answered. The IRS issued Notice 2015-17, which affirms the tax status of employer payment plans, including the $100 per day per employee penalty, but provides much-needed transitional relief from this penalty for all of 2014 and the first 6 months of 2015. Under the transitional relief, the $100 per day penalty will not be asserted against any employer payment plans operated by employers with fewer than 50 employees for 2014 and for the first 6 months of 2015. After June 30, 2015, these employers will be liable for the $100 per day penalty. This relief represents the get-out-of-jail-free card that employers and tax professionals have been hoping for. Churches with fewer than 50 employees no longer have to be concerned about exposure to this crushing penalty, at least through the middle of 2015. Notice 2015-17 affirms that employers cannot avoid the $100 per day penalty by treating their reimbursements or payments under an employer payment plan as a taxable fringe benefit, but it provides that the $100 per day penalty may be avoided if an employer simply increases an employee's compensation but does not condition the payment of the additional compensation on the purchase of health coverage or otherwise endorse a particular policy or health insurance company. Essentially, the employer says to an employee, here's some additional compensation for you. Go and spend it on insurance premiums or anything else you want. It is entirely up to you. Let me conclude by highlighting the main points. First, employer payment plans whereby a church pays for or reimburses employee health insurance premiums trigger a significant penalty of $100 per day per affected employee. And that's $36,500 per year per employee. This penalty applies to any employer payment plan adopted since January 1st, 2014. Second, employers with fewer than 50 employees since January 1st, 2014 are eligible for transitional relief. They will not be assessed the $100 per day penalty for all of 2014 and the first half of 2015. However, the penalty will be imposed thereafter. So you should discontinue any existing employer payment plan and consider other means of providing health coverage for your employees. One way that was approved by the IRS in Notice 2015-17 is to implement a plan that increases an employee's compensation but does not condition the payment of the additional compensation on the purchase of health coverage. Third, large employers with 50 or more full-time employees should terminate their employer payment plan immediately, since they are not eligible for transitional relief from the $100 per day per employee penalty. It is imperative that these employers consult with a tax professional to minimize or perhaps avoid the risk of triggering the penalty. Fourth, in the past, some employers thought that they could avoid the $100 per day penalty by treating their payment or reimbursement of employee health insurance as a taxable fringe benefit reported on Forms W-2 and 941. Employees of churches that followed this practice in 2014 should discuss with a tax professional the possibility of claiming a tax refund. The reasoning is that the employer payment plans technically remain a non-taxable fringe benefit. This tax treatment was not changed by the Affordable Care Act, but few, if any, employers will continue providing this benefit to employees because that will trigger the $100 per day penalty. Employers with fewer than 50 employees are eligible for transitional relief from this penalty for 2014 and the first half of 2015. And this means that employees whose W-2 reported the amount of their employer's payment or reimbursement of personal health insurance may be entitled to a refund. Again, check with your tax professional for further details. Fifth, the $100 per day penalty applies to all employers, including but not limited to churches. Employer payment plans have been popular not just among churches, but also among many small for-profit employers. As a result, as more employers become aware of this penalty, it is likely that Congress will be under mounting pressure to provide permanent relief. This is already happening. Several employer groups and trade associations are lobbying Congress for change, including the National Association for the Self-Employed. Some members of Congress are taking notice. Senator Charles Grassley of Iowa recently noted that he will be introducing legislation that will provide permanent relief. Any future developments regarding these important issues will be provided to you on the AG Financial Solutions website as soon as they occur. It is our objective to keep you fully informed on this and other significant tax developments. Thank you for your attention.